Welcome back to Central Colorado Ballistics. My name is Wally. In 1934, Washington did not ask Colorado for permission. It imposed definitions: machine guns, short-barreled shotguns, silencer, tax stamp, registration, federal felony, and yet Colorado did not erupt. It did not nullify. It did not revolt. Instead, it absorbed. This episode is not about rebellion. It is about administrative normalization and how Colorado lived under expanding federal firearms authority without surrendering its constitutional identity, and how by 1989, the first real fracture line appeared. In 1934, Congress passed the National Firearms Act. The law did not ban machine guns outright. It taxed them $200. In 1934, an enormous sum. It required registration, paperwork, serial tracking. Colorado did not create a parallel registry. It did not add independent restrictions. Instead, dealers complied with federal licensing requirements. Transfers followed federal procedure. The state constitution, Article 2, Section 13, remained unchanged. The promise endured, but administration became federal. Then came 1968, after national assassinations. Congress passed the Gun Control Act. Federal firearm licenses became central. Interstate handgun sales were restricted. Certain prohibited persons were barred from possession. Colorado, again, did not revolt. It integrated federal definitions into daily enforcement. Sheriffs coordinated with federal agents. Licensed dealers operated under federal oversight. This was not ideological surrender. It was practical adaptation. And in Colorado, that pattern would define the next 3 decades. In 1972, the Bureau of Alcohol, Tobacco, and Firearms became a standalone bureau within the Treasury Department. Enforcement professionalized. Audits increased. Interstate trafficking investigations became more structured. Denver became part of a growing federal enforcement footprint, not a militarized presence, not headline raids, but paperwork inspections, dealer audits, case coordination. In 1986, Congress passed the Firearm Owners Protection Act. It limited certain ATF inspection powers, protected interstate transport of firearms, but it also prohibited civilian possession of newly manufactured machine guns after May 19, 1986. Colorado did not expand beyond that federal ceiling. It did not create its own machine gun regime. Federal definitions remained the baseline. Colorado practice reflected them. In 1985, Colorado enacted what would become known as the Make My Day Law, codified at Colorado Revised Statutes, or CRS, Title 18-1-704.5. The law addressed the use of deadly physical force against an intruder. The General Assembly declared that citizens of Colorado had the right to expect absolute safety within their dwelling and places of business, and it granted legal immunity to occupants who used deadly force against unlawful intruders inside their dwelling. This was not broad public stand-your-ground doctrine. It did not eliminate retreat requirements everywhere. It defined one space, the home. Inside that space, the law favored the defender. Outside it, general self-defense principles still applied. This reveals something essential about Colorado. Liberty was structured, not limitless. Defined boundaries, defined immunity, defined responsibility. Colorado was not deregulating firearms. It was clarifying defensive doctrine, and that distinction matters. 4 years later, the first major fracture appeared. In 1989, the city and county of Denver enacted one of the earliest municipal assault weapon bans in the American West. Certain semi-automatic rifles, specific models, defined characteristics. This was not federal pressure. This was local divergence. And it raised a question that would echo for decades. Could a Colorado municipality restrict arms beyond the state baseline law? The constitutional text remained the same, but interpretation was about to be tested for the first time since 1934. Colorado was not merely absorbing federal structure, it was confronting internal division. The administrative era was ending. The judicial era was beginning. And that is where we stop. For 55 years, Colorado lived under expanding federal definitions. It did not nullify. It did not radicalize. It absorbed. It clarified defensive boundaries. And by 1989, the first true constitutional fracture line appeared. In the next episode, the courts speak, and Colorado's balance is tested. See you in the next episode. Freedom secured, rights defended.